So it's 4 p.m. and we are online. Hi, everybody. This is the first of this conversation that we are having on the Digital Protection Act. It's an issue which has been very critical to journalism. Many people are thinking of going to the court, but we thought we'd build a climate opinion on this issue and figure out how people react to it and what is the kind of response we get. So this is the first conversation we are having. We have with us Anant Nath, who's the editor of Caravan, a very passionate, you can say, fighter. He's also the earlier, he has been right at the forefront of this conversation. And he would be talking with Apar Gupta, who was the founder of Internet Freedom Foundation, also a pioneer in many ways, very passionate about the media, because it will change the nature of media, how it is practiced, because it will hurt not just investigative journalism and the news balance, it will also turn newspaper writers into probably stenographers. It's something that we keep on using it, something to run down professionals who are there, but this is the fate that likely to visit many of us if there is no intervention. So we are going to talk about it today. This conversation will be for about half an hour, 40 minutes. And then after that, there'll be some Q&A from the audience which is there. And at the end of it, you will have Mr. Raghavan Srinivasan, who's my General Secretary of Editors Guild of India, who will conclude the session by summing up the proceedings and also adding his own interesting observations. Thank you very much. Gentlemen, please carry on.
Thank you, Sanjay. Thank you for organizing this. And thank you everyone for joining. So I think the issue at hand is very simply the way regulation and laws and legislation have been put in place over the last 5 or 6 years that have created a legal framework which is being used by the government to issue takedown orders. It is being used in a manner to deprive our rights as a journalist, our rights as a free speech as a citizen, and also creating a mechanism which can be used very selectively, very arbitrarily, and is being used far more, selectively in a manner that the legal system has been weaponized to curtail speech online, which of course includes any content being put out by news organizations, independent media organizations, as well as independent creators on various social media channels. Now, the headline of our topic today is Data Privacy Act and Other Laws. So let me first start by framing a question for Apar. And Apar, of course, as Sanjay mentioned, he founded Internet Freedom Foundation. He's been at the forefront of raising awareness around issues of freedom of speech on the online space, and of course, being actively working in the legal front with organizations like the Guild and various, for representations to government on various legislations, as well as for judicial intervention. And one of the important cases that IFF had worked with organizations like ours has been held unconstitutional, but 69A is still there, which allows government a fair amount of powers to issue content takedown. Then came the fact-checking unit under the IT rules amendment. Then came a broadcast bill, which was for the time being taken back. And then came the Data Privacy Act. Now we'll start with the Data Privacy Act because that has turned out to be an act which is ostensibly for protecting our privacy online. A very noble cause, something that nobody will have a problem with. But under that act, certain key regulations have been introduced which have diluted A, the powers of the RTI, and B, created an ambiguity for journalists whether their rights would be curtailed. So for those of us who have not gone into depth of Data Privacy Act, DPTP Act, and also the background to those act, the earlier bills, which had something called a journalistic issue, because this is an issue that still requires a certain elaboration as to how is Data Privacy Act, which is meant to save our privacy actually, is actually being used to weaponize or take away our rights of both seeking information from the government and also our rights as a journalist.
Thank you so much for having me here, Anant. It's always a pleasure to work with colleagues who are journalists, who are part of media organizations. It is complementary to much of the work which I do, which is to ensure that democratic institutions remain accountable to the people of India. And throughout my journey of work, which has been focused towards civil liberties as well as institutional autonomy in our democratic framework, what has been present has been absence of any kind of data protection legislation in India. And put simply, what that means is that each time somebody takes any information which is personally identifiable related to a person, so the Googles, the Metas of the world, right, or even the government of the world, there should be an ability for an individual citizen to know the conditions under which it's being taken as a legal right. The bundle of who gathers this information from you, that information needs to be as per your consent. Consent presumes that you're put to notice, which means that you're put to knowledge that why is your data being taken, what data is being taken, how will it be used, how long will it be kept, and what happens and who's responsible in case those conditions are violated. And India has had a vacuum of it for a long period of time. So you may remember the offshoot of the Aadhaar case also being a question on the existence of the fundamental right to privacy, and does it exist under the Indian Constitution. Totally said that yes, there is a fundamental right to privacy. It's linked to all fundamental rights. And one of the fundamental rights, components of the fundamental rights to privacy, is also informational privacy. So privacy can be, we get to choose what we want to wear, we get to choose what we get to eat, but there's also privacy in information, especially in a digitized society, which most people associate with privacy today. It has something to do with data, right? But if you don't have a statutory enactment which is passed through parliament, which spells it out, right? It is a right which remains largely enforceable, especially against the private sector. Okay, so in Justice Chandrachud's opinion, he actually says that under the principles of the K.S. Puttaswamy judgment, which is the right to privacy judgment in 2017, a Data Protection Act needs to be made by the Union government. And the Union government at that point in time had, in fact, constituted a committee under retired Supreme Court Justice B.N. Sri Krishna, who had also, alongside the report in its final submission after this case, also had a draft of a data protection bill. And that data protection bill contained an exemption for journalistic purposes and freedom of speech and expression. Now, why is this important? And does it only need to be there in India? Firstly, this is important because a data protection law is providing a right to a person to refuse consent. Remember, I started by saying that if your information is being gathered, you get the right to refuse, right? And that right to refuse, what happens if, for instance, a news gathering is happening, let's say with respect to a natural calamity, a road accident, etc., etc. Do people get to refuse saying that something which is within the scope of public interest, something which is newsworthy, which carries a high amount of public interest, please don't report on this. Please don't click a picture of a political rally. Please don't name XYZ who's been accused of corruption, right? So all of these issues to a large extent would be dealt by an exemption that the data protection bill does give a data principal, the beneficiary of the law, a protection that yes, your consent needs to be taken, but there are also certain situations in which that right has an exemption, and one of those exemptions happened to be a journalistic exemption. Now, what has happened today is that the Digital Data Protection Act, which has been passed by Parliament, which comes into force next year, does not have this. And there's an accompanying injury which has also been caused to the Right to Information Act. We can get into it a little later on, in which the Right to Information Act has been amended, specifically Section 81J, which now reads as if that information which contains personal details, identifiable details of a person cannot be disclosed. And there used to be a pre-existing provision that this needs to be balanced against public interest, but that has been removed, that has been amended. So the cumulative effect of an absence of exemption for journalistic and public interest purposes, secondly, an amendment to the RTI Act, more or less means to a large extent that it neuters in not only investigative journalism, but even perhaps somebody reporting that on a municipal department which has done its work very shabbily. There's garbage which is piled up, or there's and you need to mention the municipal officer or the what is not coming, so the jail board officer, etc. So even within the scope of their public duties, perhaps potentially they can block that information, firstly under the RTI Act. Secondly, if you just get to know that information otherwise, you can possibly be prosecuted under this act for a civil claim of damages.
So, okay, very simply, our concern, therefore, to summarize what you've said, is that we as journalists, because when we are reporting on somebody, we are obviously, especially when we are doing some kind of an investigative reportage, whether it's a political person, a business leader, even a sports person, a local officer, we will write about details which pertain to their professional and personal, it could be personal affairs in terms of your wealth, your net worth. All that data can come under private data. And the gray reading here is that because we are reporting on or handling their private data, will we be under a data protection act, and whether we will need their consent to process the data. That's the overarching concern, is what
Yes.
we understand. Now, we had the Guild and various other organizations had sent some representations to the government highlighting this. You might remember there was a meeting that the MeitY Secretary had given us last year, and their response was that because this data is not being volunteered by the person themselves to us, so we are not data fiduciaries, because we are seeking this data from other sources, even if it's a whistleblower. And our concern was that a whistleblower in a political organization or in a government department gives us some data, or in a company gives us some data, then their response was the whistleblower is under Data Protection Act because they have been given this data as part of a certain professional arrangement. However, we as journalists, we didn't have any professional arrangement with the person with the subject of story. So we will not come under Data Protection Act. To this, we asked them that can this be clarified under a government order or a clarification or a certain amendment, to which of course they balked. So now there's this ambiguity that how do we process the response of MeitY that journalists handling data which we have gotten of our own investigative skills and not being given proactively by the person in charge are not data fiduciaries and therefore not under the purview of Data Act.
Anant, I would state that that is a interpretation which is not emerging naturally from the language which is present within the law. The law, firstly, does have provisions for exemptions very, very clearly, which are contained in Section 17 of the law. So, so if they're saying that, for instance, journalists do not get that information directly or do not ask that information directly, firstly, I would say that's factually incorrect. Quite often, people who also serve as sources or subjects of stories, and I know this for working with journalists, at a subsequent point in time, state that they do not wish for them to be named within a report, an article, any kind of publication. And I would say that the factual hypothetical which has been offered by the ministry does not fit within all journalistic activity. Even if we presume that the hypothetical is correct, that you always source from an intermediary or indirectly. Secondly, it doesn't take into account events which are happening in a public context. What happens to photojournalism, for instance, right? Person in a large crowd, a bystander, etc., things like that. And finally, the most curious things which does emerge is that why did previous versions of this law, for instance, if you look at the Data Protection Bill in 2019, Section 36, subsection E, it says processing of personal data is necessary for a relevant to a journalistic purpose by any person and is in compliance with the code of ethics issued by a press council of India or any media self-regulatory organization. And this provision, which is there in the 2019 version, actually is in the law of Singapore. It's in the laws of many, many countries, which has served as a model basis for the law which has been passed in India. So according to me, it seems intentional. The ambiguity actually, according to me, is not present in the law. It clearly applies to media organizations. There are some elements of information that media organizations need to fall within this law. For instance, if you have subscriber data, I would imagine you would need to fall within the Data Protection Act. But if you're reporting and that is plays into a public purpose or freedom of speech and expression, then yes, this law needed to exempt you from its regulatory ambit as it has exempted government departments, educational institutions, employers, etc., etc., etc. So I'll stop here. And I think so, Anant, lot of clarity on this is also available on the basis of the representations, the statements the Editors Guild has sent. I think it has a very consistent and deep and rigorous engagement on the lawmaking process all through the different versions of the law, and also the Press Club of India, which in fact organize different press clubs from all across India and working journalists. I think so thousands of journalists co-signed and sent a list of questions to MeitY, and MeitY neither changed the law, neither issued a clear clarification, exemption in any way, or did not engage with it to the level where there would be clarity. According to me, the law needs to be amended, but they did not even do the least to what had been promised as per press reports, in which they could have issued a frequently asked questions, in which actual questions were submitted by different press organizations.
So, Apar, there have been a set of petitions that have been filed to challenge this DPTP Act. What is the ask from these petitions? And if given the due consideration by the court, what is it that we are hoping to achieve, and how do we ensure bodies like it and other press organizations to make sure that some of the adverse effects of this act are sort of neutralized?
So if you pick up any political science textbook, most of them, when they have chapters on rights, democracy, and constitutions, they basically explain how the government is accountable to citizens on the basis of certain natural rights which emerge, which are then in constitutions, and these rights need to be considered complementary. So citizens quite often need to have these rights to keep the government, which has a lot of power, a lot of money, accountable, and the citizens' rights need to be construed and need to be institutionally recognized in a way in which one does not cut across the other, right? So we have the right to privacy, we have the right to freedom of speech, and both are constitutional rights. These need to be need to be considered in a way in which they are harmonized, and they need to be in a way in which the state is accountable rather than they are put in opposition to each other. The situation we are in, and these petitions are which are before the Supreme Court, are saying that the Digital Data Protection Act, which is there, firstly amends and neuters the Right to Information Act under Section 81J. So there are a bunch of petitions which are there by RTI activists as well as the organizations which have been behind the creation of the RTI Act, as well as ensuring that the institutional apparatus, which is the state commissions, the CIC, also remain functional. And there's been backsliding on that. These are MKSS in CPRI. And there's another category of litigants who have approached the Supreme Court, which work in beneficiary identification, in which they work with people who are entitled certain state benefits, ration holders, things like that, LPG subsidies. And quite often, these people who work for beneficiaries, they need that data, but the government may shut that out, and this may give rise to exclusion as well as corruption in government schemes. And the third, at present, include certain press organizations which have also moved the Supreme Court. They're saying that there's absence of exemption for the press, and also there's been a direct attack on the fundamental right to freedom of speech and expression. Very quickly, there are some other provisions also which I think are interrelated in these petitions, which merit some comment. The first is that Section 17 of the law creates a very broad exemption in favor of government departments. They can be notified for exemption from this law, and then they are perpetually exempted from the observance of this law. And the data protection law also is a law which can be used to gather information. For instance, if a government department has information about me, right? I get to also query that government department. Is my information stored correctly? I get to ask them for modification. I get to ask them, have you deleted it after using it for the purpose which you gathered it from me? So government departments are completely excluded based on one solitary notification. And also the law can exempt any singular private sector organization, which is very, very vague. Then you have Section 36 read with Rule 23, which provides that the central government can just ask the data fiduciary, which is, let's say, a social media company, or let's say a cloud-based provider, which is providing database services to news publication, right? Where all of your records, all of your sourcing material, all of your stories, all of your correspondence is stored. So the government can just ask them for all of that information without even registering a case, right? So this is a very wide power. It impacts source confidentiality. And finally, who is going to implement this law? There's no independent regulatory body which has been created. The government gets to pick, decide, and appoint officers of the data protection board. It pays them as well. It can terminate them. It decides their service conditions. And this data protection board, for all functional purposes, sits under the supervision, control, and power of the central government. And the central government itself is something which needs to be reported, needs to be kept accountable. So I'll stop here, but these are the petitions before the Supreme Court, and these petitions have been filed. The Supreme Court has issued notice in these petitions. I am appearing for a press organization before the Supreme Court, as well as working with several other journalist organizations and supporting them in understanding the impact of the law and what's happening in the court.
So at one end, they have taken away our powers to investigate by diluting the RTI, and therefore the most important tool that journalists had to seek information from the government has been greatly reduced. The other end, they've put us under some kind of scrutiny, even though they say that we are not under it. There's ambiguity, and there's a very well possibility that we will be. And Data Protection Board, which is the overseeing organization, is not an independent one. It's a completely government controlled organization. So the final decision will be taken by the Data Protection Board as to whether journalists come under it, and therefore all those issues around confidentiality of your sources and so on and so forth. I'm going to shift gear a bit, Apar, and come to the other pressing matter, which has become a bigger problem, or equally big, if not a bigger problem, in the last few weeks, which is the indiscriminate, one can say the indiscriminate use of both Section 69A and Section 79 3B, and the way Sahyog portal is being used to take down content on social media, which seems to be happening at a far more frequent pace, which seems to be happening far more arbitrary. So for everybody's information, those who may not be very well versed, what is 69A, and more importantly, what is 79 3B, and the Sahyog portal that the government has put together, how the powers to take down content have been completely decentralized, and the window for social intermediaries to take down content, which has been kept at 3 hours, which the government is mulling to bring it down to 1 hour. If you could just explain the issue around this, and the almost the emergency problem it is creating for journalists, or for any citizen for that matter.
So, Anant, not to be self-indulgent, but I was also a counsel in the Shreya Singhal case where Section 69
Yeah.
was constitutionally upheld and Section 66A was struck down and Section 79 was read down. Now, this is a lot of sections I've just thrown out there, so let me explain what they are. Number one, Section 69 is the power for the central government to issue directions to block online content. It has also made procedural rules in 2009, which are called the blocking of information rules, which has a detailed process, has some features of natural justice in which notices are sent to the impacted party. There's a hearing, there's an order which is passed. But the way the central government has applied this law, it does not sometimes follow it. Okay, and you have to go to court even to get a hearing when your content is being blocked. When there is an order which is being passed against you, sometimes even that is not provided. And the law was constitutionally upheld by Justice Nariman in his judgment only because he said there's a procedure, there's a process, and they will hear you, they will pass an order. And if you have a problem, you can always come to court. Now, most people are coming to court, and I represent multiple clients on this singular issue in which a copy of the order is not being given. But this is the blocking power. The blocking power is in favor of the central government. It is authorized an officer, and there's a committee, review committee, and this was the blocking power which was there for content. Section 66 was a criminal provision of law which was very vague. It said that if anybody feels offended, FIR can be filed, and this was struck down for being vague. And then we come to Section 79. Section 79 is a provision of law which has been there in laws across jurisdictions. It has been updated over the past few years given the rise of the harms which have been caused to the well-being of social media users. But the primary purpose which it served is that a telecom company should not be held liable for a telecom user who uses the telecom network for calling up a bomb threat or a prank call or something which is illegal, right? Not a prank call. I don't think so. They can be illegal. But yeah, so basically, the people who provide you the pipes or the technical facility are not liable for user generated content like online platforms, but they have to do certain things to make sure that they're immune from the prosecution. And one of the things which they need to do is to take down content. For instance, if there is some non-consensual intimate image abuse, which is sometimes today also taking the form of deep fakes in which a woman is shown in a certain way in which it causes her injury as to her reputation, her standing, possibly many other things, right? That needs to be taken down. And the way that will be taken down is the police department will notify the social media intermediary that this is illegal. Now, what has the government done? Anant, you were saying that the rules which have been made in 2021, the IT rules, the government has created a hodgepodge of multiple authorities and multiple bases and distributed this power of blocking. It has created a Sahyog portal which automates as per manuals which are now available semi-publicly and inform us that in which uh, inspector generals of different states rather than one central government can issue notices to platforms who are also on the portal by clicking on a template and choosing what content to block. There's a new story which has just come out that, for instance, the Ministry of Home Affairs, when it was also notified as an authority to take down content, has in fact passed orders every day, at least for I think so more than 200 pieces of content. And what we need to remember again and again is that the person who's impacted, quite often a press publication which is impacted, does not know what is happening. I'll just give one instance to bring all of these legalese and to ground it in a real world instance. There was a stampede which occurred unfortunately, on the New Delhi railway station. Some people lost their lives. This is unfortunate, but also shows us a mirror to ourselves as to our state capacity, which helps when the press reports it, and we can ask the railway minister, we can ask the government authorities, why are people still losing their lives in 2025? This happened last year, due to overcrowding, due to stampedes on railway stations. This should not be happening, right? So the tweets which were made on this, the videos which were circulated on this were taken down, and this included mainstream press publications and platforms which have printed newspapers. I'm not naming them, but all of this is semi-publicly available. And the ministry took it down. The railway ministry was authorized to issue takedown notices. It's been an alarming rise in the number of authorities who are using different laws, both 69A as well as 79, to take down content on social media. And the final thing I'll just end by saying is that one needs to understand that social media today does not serve as merely a platform on which people visit and they just see something and engage something, or probably from lens of entertainment or oversharing, etc. It is a vital lifeline for journalists. It is where the conversation takes place. News breaks. People respond to a story. People read your story. Especially in the age and day of AI, where summaries of press reports are made available, where there's no attribution to which platform did what news gathering and which reporter gathered what information. This is really important. Social media serves as the primary distribution channel, just like how newspapers and print relied on printing presses. Today, all press publications rely on social media platforms, and this is why these blocking powers are very, very, very suspect, and they are being exercised in a way which really is opposed to any constitutional principle.
So again, Apar, just to clarify and reiterate the gravity of the situation, IT rules 2021 mandated a three-tier structure. And if there was a problem with respect to some online content, a notice would be sent to the content creator. They would respond. After that, there would be a hearing with that inter-ministerial group, and they would finally take a decision. Of course, it's a government body; the decision will be government. But there was a certain process to it, even though it was skewed and controlled by the government. There is a Shreya Singhal judgment, which you were part of, which said that any content creator needs to be given a notice first and an opportunity to be heard. Now, not only is 69A being used under those emergency powers and sovereignty of the country, what you're saying is under 79(3)(b), under the Sahyog portal, that power to decide, which was before this residing probably with a handful of government ministries, central government ministries, MeitY and MIB primarily, has now, it seems, been given to the rank and file across state governments, to police officers, to district magistrates, to just simply click on the Sahyog portal, so and so X post or so and so Facebook video is problematic, and the social media company has to just comply without any questioning. Is that how simple it is to take down content?
Yes, it is, but few points, Lalit. Number one, the IT rules have been amended, I think so, close to 6 to 7 times. They also put in a fact-checking power. Then these 2021 rules itself were amended to put in the fact-checking power. It was struck down as unconstitutional. The union has filed an appeal in the Supreme Court. They did not get it listed for reasons I would not like to speculate on, for close to 400 days. And they have only recently gotten that appeal listed in the Supreme Court. This was one of those rare victories which we have won collectively. The second one is amendment which has taken place with respect to the Sahyog portal. So Sahyog was created earlier through an office memorandum, did not have even the fig leaf of legality in which there was an executive notification. But all of these things are anyways illegal because the parent law does not support it. But anyways, so now they have a new 31D, Rule 31D under the IT rules, which they have amended for the Sahyog portal. It does not have this natural justice safeguards of notice, hearing, order, right? Basic things which we need in a society, not being Kafkaesque. Second, it's not limited to the union government. State governments can also notify IGs as well as secretaries, but the reviews also will be done by those very departments. So there's no central government review committee. Okay. And one final thing is there's no prohibition of lack of delegation of that authority. This is why we are noticing such a spike in the number of takedowns, in which there's a common notice which comes this account is withheld in India, and we don't know why it's withheld. And sometimes even the people who have been blocked, they don't know why it's being withheld. Finally, there was also an amendment made to the IT rules again through what is called as a synthetically generated information for synthetically generated information. Again, this is this year before the AI summit, and it has certain language which does not, which is overbroad. It gives many powers to the union government to direct takedowns, requires platforms to do it as well. And basically, if you're using even a basically like the government under that can not only get the post taken down, can get the account blocked, and also your details will not only be given to the government, but they can also be given to the complainant. So, some of the phrasing in the last amendment also says that if that information appears to be false or lacks good faith, so possibly they're circumventing the Kunal Kamra judgment on fact checking. I would say that press freedom today is under several vectors of attack. It's a poly crisis in which it's economic sustenance, it's commercial viability, it's access to information, all is being negatively impacted. But increasingly, it's being formalized in a legal framework, and there's a need to push back.
I'm going to ask the same question again, just for again clarity. Once any of these government officers or police departments logs a certain content as problematic under the Sahyog portal, does the social media intermediary have any liberty to check the veracity, to respond, or even notify the content creator? Or they have to
Uh,
just simply comply the matter?
so they can notify that the government department, they won't name the government
Yeah.
department.
Yeah.
This is, I'm saying in practice what happens.
Yeah.
So both Meta and X, for the clients I have represented, they have responded that a government department has issued an order against you, right to cyberlaw@MeitY. Okay, and that's what all you get, right? That's all what you get, and then you need to proactively write to MeitY as well as the grievance officer. And sometimes MeitY says we didn't pass the order. Some state government police officer passed this order, you need to approach them. So then we approach them. But again, if you write to all of them, I have also noticed, and this happened when the armed conflict happened, in which there was between India and Pakistan. Large number of accounts, social media accounts, were restricted, of press publications. We advise these are small independent newsrooms, and we wrote to MeitY, and they were made inactive for 10 days, 12 days, and then they were restored. Rather than giving us a hearing, they restored it. But there is an injury of temporal blocking, and this is happening for entire accounts, not individual pieces of information. So, what is illegal or not illegal is being turned subjective. Again, Anant, I'll say it's not about things being problematic or not being problematic. I find certain things problematic. I find bhajan clubbing problematic, right? But that's not the law, right? The law needs to be consistently applied and within a constitutional framework, and it's not being done right now.
So not only don't you know the reason why, you don't even know who's brought you down. So you're actually
And the
meant
order
to.
is not given to you. And the order is not given to you. So it's completely Kafkaesque in its very definition.
Right, right. Okay, I think we've been at it for 40 minutes. I think maybe good time to open up to some questions, around this, or even some of the other things, I mean, which we haven't gone into detailed discussion is the entire fact-checking unit, because the fact-checking that the was put under the IT rules. I mean, we did, Apar did touch upon it, but the fact that it was held unconstitutional, but the government has now filed an appeal in Supreme Court against the Bombay High Court judgment. That's a lingering fear. Let's see where the Supreme Court goes with it. But for the time being, the fact checking unit, which would have given the government unitary and total power to decide what is fake, false, or misleading, three very vague words regarding its own affairs, was held unconstitutional. But the intention of the government remains to work in that line. So yeah, I think it's a good place to open up to some questions. Please go ahead, either type or unmute yourself or raise your hand, and we'll unmute you. While the questions come in, if let me ask a follow-up question. For even the 79 3 and 69, I mean, again, I'm going by the Shreya Singhal judgment. Does the Shreya Singhal government not apply to this? And what can media organization, what can we do to sort of get out of the mess created around Sahyog portal?
So, Anant, I would say that the first thing is that uh, the law as it exists in the Constitution, the statute book, and the rules and regulations, or even judgments of the Supreme Court, is simply not being followed. And there's no other way I can phrase this. It's unfortunate, but that's the situation we are in right now. Secondly, what can press organizations do? The Editors Guild does a great job, I would say, working with the legal community, understanding the impact of these laws, not only today's webinar, but also having an interface with the government, understanding the perspective of the bureaucracy as well as the political interests which are at play, and engaging on it with a way which is productive, right? Rather than oppositional or adversarial, right? So I think that needs to be done, but it also needs to be accompanied with a greater appetite to approach the courts. I know a lot of people say that the courts are sometimes hostile to these kind of petitions. However, that would amount to just giving up. And I don't see an alternative to contesting illegal government actions, which include the Sayog portal. Finally, I'd just like to place a small reminder. The highlight of Indian constitutional law for me personally is the press freedom cases. These press freedom cases, which include the Indian Express, Bennett Coleman, and the Sakal newspapers case, happened at a time when executive power was incredibly concentrated under a different political dispensation. And despite that, newspapers, press publications, industry associations, journalists still approach the court. So I would encourage greater courage.
Okay, thank you. I think there's a question by Murli. Murli, if you could go ahead. Murli? Okay, Sanjay, you had a question?
Yeah, I wanted to know. Can you hear me?
Yeah.
Yeah, I want to know from Apar. Do you think the journalism is suffering primarily because of the law that has been brought in, or there were other factors that you were talking about technology, about reasons of viability, the increase in the flow of information through on various platforms, and many other reasons, rather than just this factor? And secondly, if there's no pushback, how will journalism look thereafter?
I think the primary issue for journalism is economic. My own view is from the basis of the people who have gotten to know through my work, and also it's economic. A lot of it's a crisis in which I don't know. It's not unique to India, and there may be strategies to take care of it. But I do believe that there needs to be independently, autonomously state administered funds to support journalism. And I know perhaps in today's day and age that may seem like a very radical idea, but it needs to be done properly. I sometimes find myself emotionally affected when I meet young journalists and I see the conditions under which they're working. There was a person who's I'm representing pro bono in a defamation claim, who's had to let go of half of their newsroom, and even their monthly budget is peanuts. It's 3 to 4 lakhs for about 8 people, and this just makes you wonder, why do people do journalism if they cannot even having the ability to sustain themselves? So according to me, the primary issue is economic. However, when you have economic precarity, and on that you have an additional layer of hostile political economy as well as laws which can be weaponized very easily against journalists, then even people who come with some amount of privilege do not want to do this work, or want to do this work but only for about a few years of their life. And you cannot begrudge them for making smarter choices to have a better life, right? So according to me, it's economic, but there's a larger environment of hostility, and laws are playing into it.
I think Prakashji had a question. Prakashji, if you could ask. प्रकाश जी अपने आप को अनम्यूट कर लीजिए, या ऋषभ प्लीज अनम्यूट प्रकाश जी। हाँ, या
हाँ, अब हो गया है।
हाँ जी।
अपार जी, अगर आप ये सब छोटा सा पूछना है मुझसे।
आपका थोड़ा कनेक्शन वीक आ रहा था प्रकाश जी।
जवाब भले ही आप
हाँ।
अंग्रेजी में दे। हाँ, आर्टिकल 19 में हम कॉन्स्टिट्यूशन की बहुत बात करते हैं कि फ्रीडम ऑफ एक्सप्रेशन दिया है, जिस कोई पर्टिकुलर प्रोटेक्शन नहीं है मीडिया के लिए या प्रेस के लिए। भारतवर्ष में ये कहे जा रहे हैं। आप अगर ये कहें कि आर्टिकल 19 नलीफाई अगर नहीं हो रहा है तो बहुत ज्यादा उसको कमजोर कर दिया गया है। अभी अनंत ने जैसे बताया था कि राइट टू इंफॉर्मेशन के बारे में और उसके बारे में, तो आपको लगता है कि अब हम लोगों को जो सारी लड़ाई है वो आर्टिकल 19 में, जैसे अमेरिका या दूसरे देशों में है, उनके लिए मीडिया के लिए कोई प्रोटेक्शन के लिए अलग से कोई एक अभियान चलाना चाहिए?
प्रकाश जी, मेरी ये राय है कि मीडिया को आज की तारीख पे ज्यादातर लोग पसंद नहीं करते, और उसमें उनका भरोसा टूट गया है। there's a crisis of information integrity. There's a fracture of trust of people in press publications, in media and journalism. और इसके काफी कारण हैं। इसके कारण काफी ये भी हैं कि प्रमोटर जो इनकम, मतलब जो काफी इन प्रकाशन के हैं, उनके कभी कभी माइनिंग बिजनेसेस हैं, पता नहीं क्या क्या भी हैं। पर देखिए, सरकार ने भी एक तरीके से ऐसी नीतियां लाई हैं और ऐसा दबाव डाला है कि कभी कभी लगता है कि मीडिया अपना काम सही तरीके से नहीं कर रही, गुणगान कर रही है किसी चीफ मिनिस्टर, किसी अधिकारी का, मतलब, और मैं लोकल लेवल की बात कर रहा हूँ। और डर का भी तो माहौल है कि, मतलब, देखिए, ये भी तो एक खुला सच है कि ज्यादातर अखबारों में जो मीडिया पॉलिसियां होती हैं, जो किसी राज्य सरकार की हो, मतलब, उससे काफी पैसे आते हैं, उस और कॉरपोरेट भी उसी अखबार में कभी कभी पैसे डालती है, या ऑनलाइन एड चलाती है जिसमें सरकार को अच्छी नजरिए से देखा जा रहा है या उसका गुणगान करा जा रहा है। तो मेरे हिसाब से, अगेन, इट इज अ इकोनॉमिक क्राइसिस मेरे हिसाब से, जो देखा जा रहा है, और उसके वजह से, और मतलब कानून भी है, कानून भी उसमें एक बहुत महत्वपूर्ण इशू है, और उसके वजह से बहुत लोगों का जो पूरा ट्रस्ट है वो टूट गया है। और लोग ज्यादातर अपना कंटेंट सोशल मीडिया से भी ले रहे हैं। वो जो बहुत सारे ऐसी बात नहीं है, यंग लोग ही करते हैं, ओल्ड लोग, यंग लोग व्हाट्सएप पे देखते हैं। उनके लिए व्हाट्सएप की जो दुनिया है, जो खिड़की है, उसमें जो दिखता है, और एक न्यूज़पेपर में जो दिखता है, वो दोनों स्मार्टफोन पे ही दिखता है, दोनों एक ही है। तो उन दोनों में कोई डिफरेंस नहीं है, उन दोनों में कोई अंतर नहीं दिखता उन्हें। मेरे हिसाब से जो प्रेस प्रेस के ऊपर जो अभियान चलाना चाहिए, वो संविधान के आर्टिकल 19 पे तो बेस होना ही चाहिए। पर मेरे हिसाब से जर्नलिस्ट को ह्यूमनाइज करना, जर्नलिज्म को ह्यूमनाइज करना, लोगों को समझाना कि जर्नलिज्म कितना महत्वपूर्ण है। उससे स्कैम पकड़े जाते हैं, सरकारें गिराई जाती हैं, चिकित्सालय बन जाते हैं, और कभी कभी लोगों की नौकरियां लग जाती है, घर में पैसे आ जाते हैं, खाना आ जाता है। वो सारी चीज़ों का बहुत बहुत ज़रूरत है आज की तारीख पे। और मेरे हिसाब से ये अटैक्स जो मीडिया पे हैं, उनकी रेपुटेशन पे जो है, जर्नलिज्म पे जो है, वो सिर्फ संवैधानिक नहीं होने चाहिए, सोशल भी होने चाहिए।
Murli, did you want to ask a question?
You're trying to ask for a long time.
Yeah. Okay. Uh, okay, one last question from me, Apar. Uh, Often when we go to the government and raise issues around fact-checking unit, around this Sahyog portal, the response that government puts up is that there is problematic content online, and we can't deny that. There is all kinds of content. Now, what should be our response? That, okay, if this needs to be regulated, what kind of a regulatory system to adopt so that it doesn't become a tool which is used by the government, definitely not a tool which is used by multiple parts of the government in a very arbitrary manner, without any oversight and without any review, but in a manner that it solves the problem and also doesn't encroach upon our space.
I'm not opposed to regulation. In fact, a lot of the work which I do is towards social media regulation. And I don't believe that the state should not regulate technology, digital communications. However, that has to be within the corners of the constitution, its constitutional limits. So there are simple things which can be done, which are not being done. Laws can be more precise. They can have ingredients as to the legality. They can be through parliamentary enactment, put through a statutory committee in which they are examined. There can be safeguards which are there, which are, for instance, natural justice. A person whose content is being taken down is being put to notice. There's an opportunity of a hearing. There's a reasoned order which is passed. There needs to be a public disclosure of the order. Article 19(1)(a) also includes the public's right to know, right? At the very least, if you cannot make the order public, you can at least say which websites are blocked. Why are you shutting down the internet? Has been stated by the Supreme Court to be disclosed to members of the public. So similarly, any kind of other restriction on 19(1)(a) also similarly needs to be disclosed. So Anant, I think the response of the government sometimes is facetious. It is disingenuous, I would say. It's not accurate. Nobody disputes the power of the government. It is in the manner of its exercise which does smack of unconstitutionality.
Thank you. Mr. Narapar had one question. So please unmute yourself.
So again, also type in the thing. I think so.
Yeah, I think we can use the chat and questions.
I think he's unmuted himself. Yeah. Yes, sir.
Yeah.
So Narabak, please carry on.
Sir, you're not audible.
Okay, I think maybe not able to connect. Okay, so I think if there's a question in the chat box by Ayushi. Thank you for the insightful discussion. Question is, how does the explicit notice and consent mechanism under DPDP Act will impact journalism, especially criminal cases where consent may not be forthcoming, given the lack of clear exemption? So although we have covered that, but Apar, you want to just maybe quick reiteration of what you have said before?
I don't know how it will work. What do you mean by criminal cases? So there are some protections which are available to accused, but even that's not followed strictly. There are provisions also for protection of witnesses, their identities in certain forms of crime. So I don't know, but see, if you mean in terms of media trials, etc., there are pre-existing remedies for protection of the sanctity of the trial, of the process of adjudication, and primarily it is that there needs to be a post-decisional publication that after it completes, and that does present a problem sometimes for journalists. However, by and large, I think this may also be one of those thinner categories in which the impacts may be mitigated, because sometimes criminal cases also, by their very nature, are entering into the court system. The court system does not have a clear judicial information management policy. Courts are considered to be public offices and the records are presumed to be public, and thereby it may be queried under and you may be open towards doing that. There is also a long list of judgments which are there from Virajkar, which says that the rule is open courts. So this may be one of those situations in which the DPDPA may not be able to restrict a journalist as well. But it depends on the fact situation which is before us.
All right. I think we are coming to the end of our time now. Since I don't think so there's any more question, and unless Mr. Nalapart is able to ask his question, should we bring this to an end, Sanjay and Srini?
Yeah.
I think Raghavan is going to take it from here.
Yeah. Okay.
All right. So thank you, Anant, and thank you, Apar, for a extremely illuminating, if even more worrying, look at what is actually happening in the area of um, the right to exercise journalistic freedom, if I may put it that way. Because while some of the actions are very broad and sweeping, they have very particular impact on the way that the media and journalists carry out their work. And clearly, after you took us through the iterations through which, for instance, the current act as it exists has itself passed, it becomes clear that there is some it's not just poor drafting, which has been the case with a lot of other legislation which this government has passed in recent times, but here there appears to be a clear intent to essentially retain the power of controlling what the public can see, read, hear, or consume. The government has left itself as the final arbiter and the sole arbiter of that, that the principles of natural justice, of due process, and even in whatever limited fashion, review and a process of appeal which existed earlier, that has also been done away with. And read in conjunction with what's been done in terms of the sweeping exemptions given to government, under the RTI Act, it becomes increasingly difficult. If one of the key roles of the media is actually to hold government to account on behalf of the public. Individual citizens, may not be able to do that. In that sense, the media does that role in the public space, and that is clearly something which is not something which the government appears to be comfortable with, and has armed itself now with the legal powers to control it. Correct me if I'm wrong. Earlier maybe some of these actions there was some possibility of review action. Now they're all given the clothing of legal validity because if the law says so. So it is a depressing note on which to end this discussion, but I think also I take hope from what you said at the end, that even at a time when the threat to press freedom was at its greatest, media institutions did, push back, fight back, and they managed to win some of their freedom back. Hopefully, I think that is a takeaway for all of us in the media here, that we continue to resist, we continue to push back, we continue to question till such time as some of these very basic fundamental rights, constitutional rights, are restored in some fashion or the other. So thank you once again on behalf of the Editors Guild. For those who are not members who joined in today, the Editors Guild of India is an independent, fully self-funded organization of media professionals, senior media professionals, and we basically work to uphold the best standards of journalism and uphold media freedom. And that's our core remit. So thank you all for joining us today, and hope to see you in our next conversation very soon.
Thank you for having me.
Thank you.
I'm deeply honored. Thank you so much, everyone.
Thank you.
Thank
Thank
you.
you. Thanks so much. Well done.